Plan and Integrated Resources Plan for Duke Energy's companies in North Carolina. Are there any issues that we need to address before we start cross?
No, sir.
All right. Hearing none. At this point, well, it's going down some, hadn't it? Sigfer.
No questions. Thank you, Chair Brawley.
Thank you, Ms. Kress. EDF.
Morning, Chair Brawley. Just a few.
Yes, sir.
Ben Smith for Environmental Defense Fund. Is it true that for the ELNG discussions in your testimony, including rebuttal testimony, you're not yet asking for cost recovery or approval of the construction?
That is correct. We are asking for alignment on the generic assumption so that we're looking for the commission to see that the fuel security provided by ELNG is equivalent to that from a fleet perspective for CCs 4 and 5.
Okay, so I heard reasonable assumption of the generic modeling. Is that what you're looking for? The commission to sort of co-sign this as a reasonable assumption that companies could take in future modeling?
Not only future modeling, but any future CPCN.
Thank you. And so with respect to your request to the commission, can you sort of summarize what Duke has done thus far to show this option is the least cost when compared to any alternatives?
Yeah, I think the most evident thing on the record here is the fuel security evaluation that the IRP and NTAP modeling did. That took into account the fixed cost, the O&M cost. I think a witness from NCSEA Glick, stated that O&M costs were not included. That's not true. They were part of the cost that was modeled and the variable cost. So the IRP team did a very thorough cost evaluation of ELNG in that fuel security evaluation, and it came out least cost versus the EFT option from the Gulf Coast.
And I know there's been some dispute about first of a kind or sort of how to classify that. And I think you all take the position that this isn't a first of a kind technology. But I guess what I want to ask with respect to that is, if it isn't first of a kind, then why are you just now having to ask the commission for sort of approval for generic assumptions on capital costs and I suppose O&M costs as well?
Could you restate the question?
Sure. I believe you all have taken the not a first of a kind technology. Is that right?
That is correct.
And so in this proceeding, though, you are asking the commission to take to sort of give approval of generic assumptions, I believe, for capital costs and I think O&M costs with respect to this ELNG technology. Is that right?
Well, we actually modeled it as a service, just like firm transportation from the Gulf Coast. The company, Duke Energy Carolinas, Duke Energy Progress, we don't own Transco. We don't have capital in that as a service provided by a third party. So just to have an apples to apples comparison, ELNG was modeled as a service.
Okay. And so, but for the purposes of discussing what you're asking the commission to do in this proceeding as a service, is this the first time that you've come forward and asked the commission to sort of make or approve your assumptions on costs?
Yes, and I think I know where you're going here. And the reason, commission, and this is not new news, and we've said this in many prior filings, we've been deficient in the Carolinas of natural gas capacity, natural gas supply. Atlantic Coast Pipeline was supposed to bring the gas we needed. It didn't happen. So we've been focusing our energy on getting more gas to the Carolinas. We have a solution in MVP Southgate and Transco SSE expansion. They are in flight, under construction. Now that we have that capacity, we want to optimize that capacity on behalf of our customers. We want to increase reliability, and we want to make sure that firm transportation capacity is utilized to the highest degree. So, Mr. Smith, I think the reason we didn't model it before is because it didn't make sense where we were in our firm transportation portfolio. However, now that we have MVP Southgate and Transco SSE in flight, it does make sense.
So before, and please correct me if I'm summarizing this incorrectly. Before you had constrained capacity in the gas pipelines, and now you may have some, I don't know if excess capacity is the right phrasing, but capacity that you could store on site that you didn't have before. Is that right?
I don't think excess is the right word. I think we have, for our planning purposes, contracted volumes that are appropriate for our combined cycle fleet and our fleet as a whole. So ELNG presents an opportunity to where we can further optimize that capacity, let our customers have access as much as possible to low-cost Appalachian gas supply. And ELNG would not be possible without the increased capacity that the Transco SSE and Southgate pipelines are coming for our fleet.
So before you may not have had enough, but now you have enough and may have some that you can include for an ELNG pipe process.
Again, we're trying to make sure we have alignment on fuel security for our fleet, and for our combined cycle fleet in particular, we use interstate firm transportation historically as a means to meet that. What we're bringing this commission today and in this proceeding is ELNG brings another tool to the tool belt to allow us to provide that fuel security to the combined cycle fleet and the fleet as a whole, now that we have additional pipeline capacity into the Carolinas.
Thank you. I'll move on to my next topic. Were you all in the hearing room yesterday during the IRP NTAP panel, Duke's IRP?
Yes.
Yes.
Okay, and I believe it's Mr. Hofflick, am I pronouncing that
That's
correctly? Mr. Snyder sort of deferred to a question that I asked him to you, I think, or he referenced you as a hydrogen guru or something.
Well,
to
I've
that
never kind of been referenced as that.
effect.
I
So-
appreciated it. Yeah.
I'm going to try and paraphrase the question I asked yesterday, but hydrogen and to some degree carbon capture sequestration were litigated issues in the last carbon plan proceeding. I want to know what Duke has done since the last order in the last carbon plan proceeding to advance hydrogen development and carbon capture sequestration, both inside the fence and outside the fence, so to speak.
And I think your question said beyond the CT combustion turbine.
Yes, sir. That's what I mean by inside the fence, outside.
Yeah. So it's a really good question. I mean, I'll start with the DeBerry demonstration. We talked a lot about our DeBerry demonstration, producing 80 megawatts on green hydrogen, sort of a record, but that's on the combustion turbine side. But we are producing green hydrogen at DeBerry as well. And so we are learning lessons, producing that green hydrogen, in terms of the means of production, safety. We have a very stout hydrogen safety manual that we've developed and we share with the industry. So we're sharing our lessons at DeBerry more broadly, both domestically and internationally. So other demonstrations and other work can kind of pick up where we are, and we also learn from those, right? So that's one example. We also work with EPRI, or the Electrical Research, Electric Power Research Institute, and we sit on many technical committees that are focused on hydrogen transportation, hydrogen storage, expanding the storage and transportation, as well as hydrogen production technologies. So we were technically involved with EPRI and lead a lot of that work and help direct EPRI in that area. We also meet with select hydrogen producers with production technology to, discuss with them our needs and what we think our needs are and how they could develop that technology to meet those needs, as well as allow us to evaluate that technology. So we meet with those individual companies. And then we may have mentioned this in the last CPIRP, but I think it's important to bring up. I don't know if we talked about it a lot, but when we were pulling together the Southeast Hydrogen Hub application for the Department of Energy, we actually met with hydrogen users. So beyond power generation, to understand what their needs would be for clean hydrogen and how that may be built together with our need, right? So I think when you think about hydrogen, you have to think about it very broad also, with many, many use cases. So I would say I think I've hit the main points that I wanted to hit on the hydrogen. Carbon capture sequestration, some similarities. We, again, with EPRI, we work with EPRI on the carbon capture and sequestration aspect. We are right now finishing up what we call a FEED study. That's front-end engineering design, where we get the details of, we get down to pipe sizes and cable size and very detailed cost analysis and performance at our Edwardsport facility in Indiana. So that's a FEED study, not just for capture, but half of it is the sequestration, the geology of sequestration. So we've been working on that with the Department of Energy for, I believe it's almost 2 years to move that forward. And those lessons from that work will also be shared.
Thank you. No further questions.
Thank you, Mr. Smith. NCSEA.
Good morning, Justin Somolowski on behalf of the North Carolina Sustainable Energy Association. And good morning to the panel. Most of my questions are going to be concerned with the enhanced portion of the proposed ELNG facility. But before I get there, I just want to ask a initial question on the supplemental statement you all gave on live testimony yesterday. Mr. Mitchell, your fourth point discussed the need for independent analysis of ELNG, and the companies are committed to continuing to engage with public staff, and if ordered by the commission, any necessary third parties to evaluate the sufficiency and cost reasonableness of the ELNG modeling assumption, correct?
That is correct.
Was public staff made aware of this beforehand, or was that live negotiation as well?
This was my testimony that we created. We did not negotiate or talk to public staff prior to such testimony.
Okay, thank you. I appreciate that clarification. Moving forward, is it still the panel's testimony that a tank for the intraday flexibility needs to be increased by 25% to do the enhanced intraday flexibility capability?
For clarity, because we're bordering confidential information
You're
here.
not
So,
ready to take us to confidential yet. We'll get there.
okay, I'm sure we will. Are you referencing the Appendix I graphic?
Yes.
Yes. So that is illustrative, what that is supposed to be showing. But yes, a portion less than 25% is modeled to be assumed for enhanced capability.
So at a certain point, when you're designing your tank sizes, not going into the confidential session again, that is baked into the assumption when you're designing.
Yes, and I think that's one of the things that I think we've tried to tell the commission here is we have accounted for the costs, but not all the benefits. Because it's very difficult to say what volume of solar are we going to have in 2037 and how is that volume of solar going to perform hour by hour in 2037 on any given day. So it is extremely difficult to model and encompass. So that's why, you know, we're bringing the commission to say we've accounted for all the costs. We just haven't accounted for all the benefits.
Thank you. You got to my next question. But then, Mr. Mitchell, on direct, do you recall giving the example of an April afternoon where the ELNG can vaporize to help address some intermittency with certain resources?
I remember talking along those lines. I don't remember verbatim what I said, but yes.
Okay, thank you. So that was, understand your qualification. That was just an example of the capability. That wasn't a data-driven example of that's when it will be most likely used for that purpose.
Again, I'm not the IRP NTAP panel, but I know they've been excused, so I'll do my best to answer the question here. Modeling in Encompass is weather normalized. To my knowledge, it doesn't take into account intraday solar intermittency. So yes, it would be very difficult to try to model the enhanced capabilities in Encompass.
Okay, thank you. Mr. Hoffler, can you grab NCSA's potential boundaries with all the flags sticking out of it? Yes. And can you all turn to tab 55? Chair Brawley, just for your awareness, I alerted lead counsel for Duke yesterday that I noticed a discrepancy in my preparation. In NCSEA's index of potential cross exhibits and the hard copies, tab 55 is the exhibit I want to address. But I believe on the electronic versions that were forwarded to you, they were misnumbered. So if you're looking at your electronic version, it's going to be tab 54.
Okay, so let me see if I understand this. On the electronic, it's tab 54.
Correct. And
In your notebook, it is tab 55.
correct. And I apologize. I caught that so late in the hearing.
Well, and this is a data request, your data request number 14 and item number 14-2.
Yes, sir.
Okay.
So panel, I think Chair Brawley identified the document for you.
Okay, so have y'all located the hard copy?
Is this on the ELNG question?
This is, we're going to go into confidential session.
So it's for Mr. Mitchell
Yes,
then?
yes.
Okay, so this is confidential and you're asking for,
Yeah, I'm sorry. You were the closest.
Right.
are you asking for a confidential session right now?
I was gonna identify and mark it, and then I was gonna move us into confidential. Yes, sir.
Okay, so NCSEA Cross Duke Natural Gas Rebuttal, this will be Exhibit 1. And it is your potential 54 in electronic, 55 in paper.
Yes, sir. Thank you. And just for clarity of the record, I want to make sure that is marked as confidential exhibit 1.
It is confidential.
Thank you, sir.
Okay, I will identify it for the record. And at this point, I'll move us into confidential session. Okay, so I'll make the usual announcement. If you don't know that you're allowed to hear this, you are not allowed to hear it. So please leave. All right, looks like Okay. Mr. Neal?
Thank you, Chair Brawley. Again, David Neal for SACE et al. You testified in your rebuttal testimony about various environmental challenges to pipeline projects in our region, including MVP, Southgate, Transco, SSEP, correct?
Yes.
And you're aware that the first case you mentioned on page 29, starting at line 13, has since been dismissed by the plaintiffs and is no longer pending in federal court.
Yes, all 5 cases that SCLC is involved in, I believe 4 are active and 1 was voluntarily dismissed.
And the second case you mentioned on the next page, top of page 30, I guess you weren't aware that the Southern Environmental Law Center does not represent the plaintiffs in that case.
I am not an attorney, but it was my understanding that as my testimony is involved for your representation of Say Sierra Club, Say Sierra Club was in all 5 of those legal challenges, or one or the other.
And in your testimony, you assert that litigation relating to the enforcement of environmental laws is the proximate cause for upward price pressure on natural gas infrastructure. You'd agree that you did not identify any other reasons for upward price pressure on that gas infrastructure in your rebuttal testimony.
I would, we answered several discovery questions on this, so I'd be happy to go to those. But, the price of Mountain Valley Pipeline did not triple because of labor shortage of welders or because, they couldn't find a hotel room or, steel costs go up. Yes, there's other factors than just litigation, but the fact that they were delayed 7, 8 years, that is the primary cause of $6 billion of increase. That would have not been the case otherwise of the litigation.
Well, you would agree that even without litigation, pipeline companies must apply for and receive required environmental permits before they can proceed with construction.
That's correct. And in the case of Southgate and Transco, they have, and you're litigating them.
And you would agree that compliance with governing state and federal environmental laws is not optional.
I am not an environmental expert nor testifying on behalf of the pipeline operators, but these are both well-established pipeline operators. And I mean, even in the case of MVP Southgate, you look at North Carolina, they're not in high quality water zones, yet they're building to a high quality water zone standard, yet that's not enough for these petitioners.
Failing to abide by environmental permits can lead to fines or other enforcement actions, absent any environmental litigation brought by nonprofits, and that those fines or stop work orders could themselves increase costs or lead to delays, correct?
I mean, that's a hypothetical, but I don't think they're going to be $6 billion of DEQ fines against the pipelines.
You recognize that MVP Mainline was found to have repeatedly violated numerous provisions of West Virginia's Water Pollution Control Act, even as far back as 2019.
It was a 300-mile pipeline through the mountains. That it's expected things will go sideways at times. And, I will state, Commission, and this is something listening in to the Fourth Circuit hearings on these, the companies being Williams and MVP Southgate, their position is they don't want to create, harms to the environment. They want to get in and get out. They want to get the pipe done. What happens is if you dig a hole and have to leave it open for years at a time, that is not the best case for environmental harm. You want to close that hole. You want to get in and get out. And what this litigation does when it slows the process of these pipelines coming in, going into service, bringing reliable and low-cost fuel to the Carolinas, for example, it has the opportunity to create more time for these environmental issues to occur.
Now, again, turning your attention to, you've got the binder up there. This would be potential cross exhibit number 54. Chair Brawley would ask that this be marked as SACE et al. Cross Duke Natural Gas Rebuttal Exhibit 2. consent order from the West Virginia Department of Environmental Protection. Do you have that?
I do.
So make sure it's marked before we proceed.
This is not confidential.
This is not.
Okay, so this will be Sace Cross Duke Natural Gas Panel Rebuttal Exhibit 2 based on your potential cross 54. It is identified.
So did you review examples like this when you were testifying that it's litigation from environmental nonprofits that lead to these cost increases where MVP was found to be violating the law by state regulatory agencies?
So I did not look at this exact instance or this document. However, I've seen similar ones, but let's call it for what it is here. Look at the time, this date on this. This is 2019. The pipe was supposed to be in 2018 into service. The only reason it was not in service in 2018 was because of litigation from environmental groups. So this would have never happened if the pipe was in service timely.
So it's your testimony. You're asserting that there would have not been any water quality violations if the pipeline had been in service?
No, that's not my testimony.
Okay.
I'm not the pipeline nor an environmental expert. I've already stated that. What I'm simply saying, if there wasn't litigation delays, the pipe was expected to be in service in 2018, and this was dated 2019.
Well, you see that the first 11 pages include numerous examples where state inspectors issued notices of violation, finding, for example, that MVP caused conditions that are not allowable in waters of the state by creating sediment deposits on the bottom of the stream. And yes, I have heard your testimony that.
So,
you
you know,
believe this.
I'll comment to this. So this is West Virginia. They have mountains. We're talking Rockingham County in North Carolina. I have believe it's 52 feet of stream and like 3 acres that all this litigation's about. I mean, 3 acres, you can't even get a megawatt of solar on that land. Yet that is the scope of what is driving up cost, commodity volatility risk for our customers.
Well, again, after that 14 pages of notices of violation, for purposes of not cluttering the record, we did not include all 170 pages of pictures documenting those violations. But you see that after you get past page 14, the regulators in West Virginia documented those water quality violations.
Chair Brawley,
Yeah.
we're getting far afield here. To the extent I understand Mr. Neal's position that Mr. Mitchell made a statement about the increase in cost for FT, but we're getting really deep into the issues underlying these environmental positions, and I don't understand the relevance to this CPIRP hearing.
Chair Brawley, Mr. Mitchell made the allegation that environmental litigation was the proximate cause for all, it made the assertion essentially that all upward price pressure relating to achieving firm transportation from natural gas is due to environmental litigation. We don't have the opportunity to provide SIR rebuttal in these proceedings. My only chance to delve into those assertions is through cross-examination.
Well, at this point, I'm going to say that I think you've made your point that you think he's wrong when he says that. The record will reflect that. We'll give this part of the discussion the weight that it deserves when we make a decision. But I would ask that you've made your point, move on to something else.
And if I could, maybe we could stipulate into the record of just a couple other documents so that we can make that point in the brief and speed up the cross-examination.
Explain to me what you just asked me.
Well, I understand the chair's request to move the cross-examination along. Again, Duke has made an assertion that we would like the chance to rebut. Our only chance to do that is here on cross-examination. One way to speed that up would just be to stipulate into the record a few other exhibits, and that we could then point to those in our briefing and making our responsive arguments in the brief.
So what you're going to do is offer some some of your potential cross exhibits,
Yes, Chair Brolly.
but not actually conduct cross on them,
That's my proposal.
just to have them admitted to the record. And then, okay, well, let's take a look at them. Which ones are we talking about?
Well, the next one was going to be potential cross exhibit number 51. Mountain Valley Pipeline agrees to pay Virginia $2.15 million for environmental violations.
Is that a news article?
That is a news article, but if you would prefer, there's also the consent decree. We could take judicial notice of the consent decree instead of the news article.
And that is your potential 54?
Potential 51 is the news article.
Yes. The consent decree is,
The consent decree is potential 52. Consent decree entered December 11th, 2019 in the Henrico County Circuit Court in the case of David Paler versus Mountain Valley Pipeline, case number CL 1800687-4-00.
is there objection to taking judicial notice of a filed consent decree?
No, Chair Brawley, no objection.
Okay, so from your, this will be
If it's just
case number CL 1800687-4-00. This is from your potential cross-exam number 52. And this is a consent decree, David K. Paler et al. Plaintiffs v. Mountain Valley Pipeline LLC defendant. Is that the document you're referring to?
Yes, Chair Brawley.
Okay, so without objection, we will take judicial notice. And that was your okay, what else?
Mr. Mitchell was just a moment ago making editorial comments about the environmental concerns we raised to the North Carolina Department of Environmental Quality relating to the 401 water quality permit. So we would ask that potential cross exhibit 50 be entered into the record at the appropriate time, which are the comments submitted to the Department of Environmental Quality relating to that 401 water quality certification on July 3rd, 2025.
Okay, so this is a letter that you sent.
Yeah, there are comments to an environmental, the environmental agency that details the concerns about erosion, sedimentation, and the stream and wetlands crossing and the dry ditch open cut crossing method planned by MVP Southgate in North Carolina.
Is there objection?
No objection, sir.
Okay. I think, gosh, I'd have to take this as an exhibit.
Yes, sir.
It's not something that I would take judicial notice
I
of.
agree.
So this will be exhibit 3. It is your number 50. Okay, it's identified for the record and without objection.
Correct, no objection.
Is
Chair Brawley.
admitted to the record. Anything else?
I don't have any other exhibits. I just had a couple other questions related to another statement in Mr. Mitchell's testimony that touches on this issue. It'll be brief, and then I'll have one last category.
Okay, we'll do that.
You included in your testimony a lengthy quote from Judge Henderson. Again, this is on page 33, lines 24 through 25, which included the statement, "These groups do not need to win their lawsuits. Indeed, they rarely do." Do you recall that quote?
Yes, Judge Henderson said that in previous Sierra Club litigation against MVP Southgate.
And you would agree that when it comes to the MVP mainline, environmental groups won a number of lawsuits before federal courts.
Yes.
And groups can only win lawsuits when the courts determine that there were meritorious claims, correct?
I'm not an attorney.
You think a judge will allow a lawsuit to proceed if they think that's not a meritorious claim?
I think you're calling for a legal opinion. He's answered your question.
Again, Mr. Mitchell's the one that brought this issue into the case. I'm just probing it, but I've heard the chair and we'll move on. Putting aside this question of environmental review and permit challenges, you would agree that there are additional factors that are causing upward pressure on the cost of securing firm transportation that you omitted from your testimony, correct?
There's upward pressure on every resource in this plan. And if you want to talk about steel, inflation, higher interest rates, I'd argue that would affect other more capital intensive resources like battery than solar more so than gas. So yes, there are other upward pressures, but my testimony is focused on the primary upward pressure on pipeline infrastructure has and continues to be litigation from environmental groups.
Again, Chair Brawley, I'm abiding by your directive to not continue to probe this issue. He keeps bringing it up. So I'm a little bit at a loss of how to cross this witness when he's introducing into the room testimony I'm not allowed to cross him on.
Well, I think he's answering the same question the same way. And if you,
I said, putting aside environmental litigation, do you agree that there's other upward price pressure? And he keeps coming back to environmental litigation. So I'm going to abide by the chair's directive. I would just ask that the witness also be directed.
well, I'll tell you what I think I'm going to do right now. I'm going to take a 15-minute recess so people have a chance to calm down. Let's do that. We're in recess. During the recess, I consulted with counsel and, Mr. Neal, I guess you do have a point. He did put it in. So if you want to continue to talk about whether or not, I cut you off.
I'm laughing at Commissioner Tucker, not you.
Yeah. So, you will have the opportunity to rebut the testimony about the impact of environmental litigation.
But Chair Brawley, if I could be heard just for a moment.
Yes.
Understanding your ruling and accepting that, I just hope that given the subject matter of this hearing, that we don't get into litigating the underlying issues of the documents that Mr. Neal is trying to present. And that's what the previous questioning and answering, well, whether he intended or not, it elicited. And so I just wanted to be heard on that point.
I understand, sir, and part of the reason for 15 minutes was longer than we needed, but I wanted everybody's heart rate to have a chance to go back to normal because the tone was getting a little testy. And I hope that we can go at this, I guess I would use the phrase, just a little more cold-blooded. Just stick to the facts and let's try to leave the emotion out of our voice. At this point, Mr. Neal.
I appreciate that, Chair Brawley. And again, I'm happy to make this to expedite this as much as I can. I will say maybe this will help to shift the tone. Mr. Mitchell, have you seen the 1942 movie Casablanca?
Fairly certain my mother made me watch it when I was a child, but I don't recall it.
It's a great movie. I highly recommend it. There's a scene, I hope you remember, with Claude Rains' character, Captain Louis Renault. He's shutting down Rick's Cafe. And asked for the reason, he says, "I'm shocked to find that gambling is going on here." Of course, the punchline is then he's handed his gambling winnings. Just to tie on a bow, and as I read your testimony, you were shocked to find environmental groups challenging gas pipelines. I'm happy to move on from that issue, but I'll just leave it at that.
Is that a question?
It's not a question. It is an
Well,
attempt.
I can
move
respond
on.
to it if you like.
I take it from your work, you're familiar with INGA, the INGAA.
Yes,
That's the Interstate Natural Gas Association of America.
that is correct.
And you would agree that this trade group would be well positioned to understand factors that are affecting costs for natural gas infrastructure?
I would say that yes, they would.
Chair Brawley, I think there's one more document I'll just ask to take judicial notice of. I don't even need to ask questions about it. It's a NOPR from FERC. It is potential judicial notice document 5 from SACE.
Okay, hold on. You've got, all right, I just opened a potential just judicial notice and there was only one thing in it.
Oh,
Okay.
that's from redirect, I think. This is
Okay.
potential
Is
cross
this
judicial notice.
revisions? Okay.
It's 195 FERC paragraph 61128 from 18 CFR part 157 related to revisions to the blanket certificate program from May 21st, 2026.
That's your potential judicial notice number 5?
Yes. And if we
Okay.
just take judicial notice of that, I don't need to ask questions about it.
No objection, Chair Brawley.
Okay.
So moving to one other topic, you recognize that interstate pipelines are built to last for decades, correct?
I'm not an expert on the depreciation of interstate pipelines, but yes, they are generally in decades, yes.
And so when weighing the costs of those long-lived assets and whether ratepayers should help to pay for those through the firm transportation contracts that Duke enters into, a relevant consideration is whether and how, for how long those assets will exist and whether they're compatible with the North Carolina law that requires Duke to achieve carbon neutrality by 2050. I mean, whether you agree or not, that's a consideration the commission may want to consider.
Can you please restate your question?
That these long-lived assets, customers end up contributing to those in part through the firm transportation contracts, correct?
The long lead and what we're talking here specifically, say Transco, MVP Southgate, those are not the company's assets. The companies sign for rights to service on those assets. So I think where you're going is, Mr. Snyder talked multiple times about the different pathways, the 2050 to abide by the law. We have a portfolio where we can adjust the contracts as needed to meet and abide by that. So, we're not signing 40-year contracts, Commission. We're a fraction of that.
All right, turning to your rebuttal, page 19, lines 10 through 12, you testified that, quote, the public staff, and we're going to get to how this has changed, but at this time you testified, the public staff recommends delaying a decision on CCs 4 and 5 until the 2027 CPIRP, based primarily on skepticism regarding need, and therefore further asserts that there is more time to evaluate ELNG. Do you see that part of your testimony?
I do.
And again, recognizing that this was before public staff testified on the stand on June 11th about changing their position on CC 4 and 5. I just want to probe this a little more at page 47, lines 6 through 11. You testified that, quote, development of facilities that would be subject to the public staff's recommended delay is also well underway, with the companies having executed contracts for the procurement of some major components. And you continue, there are logistical and contractual challenges that will likely lead to incremental costs associated with deferring the targeted in-service dates for the facilities that are further along in the development process. Did I get your testimony right?
That's mine, yes.
Oh, that's yours, okay.
Yeah.
And by facilities that would be subject to the public staff's recommended delay, you're referring again to what I read before, the recommended delay of CC 4 and 5?
Well, it was CC 4 and 5, as well as the CTs. I guess we're calling them 6 and 7 now.
And you recognize that CC 4 and 5 have not yet been included in an approved NCUC near-term action plan, correct?
CCs 4 and 5 were in the 2023 plan as part of the NTAP. The stipulation and the order went through CCs 1 through 3, not 4 and 5. They're waiting past that last order.
Well, you would agree that there was a stipulation that Duke entered into with the public staff, Walmart, and CCBA that, among other things, included an agreement that Duke would not submit an application for a CPCN for CC4 or CC5 until after this carbon plan proceeding, correct?
I know there's discussion. I have stipulation somewhere in here. I don't know exactly where I've got it, but I mean, there was. Sorry, go ahead and ask that again. I'm gonna make sure I get it right. Go ahead.
I'm hearing static.
Audio check.
Static, I don't know where that's coming from.
I don't know if it's like anything to do with that flood, is that?
Yeah, but well, it was making it hard for you to.
Yes.
Okay.
Yeah. Happens. Yeah. Yeah.
record and come to order.
That was actually my last question. Chair Rowley.
Were you going to ask the question again?
No,
No.
I think we already covered it.
Okay.
Okay, well, I did want to make sure that you had ample chance to defend yourself.
Thank you, Chair Rowley.
Okay. Public staff.
Thank you, Chairman. Will Freeman for the public staff. Panelists, thank you for being here. Mr. Mitchell, do y'all remember when, and this is a compliment, so when PSNC was going to run that line to the Person County facilities and they were going to fix their line anyway, and you said, hey, we'll chip in a little bit and make it a little bit bigger. And it kind of saved money for everyone. That's a broad characterization, but do you know what I'm talking about?
Yes, that was a new pipeline from, point A to point B. So you're sizing a brand new pipeline. Yes.
I think now with all this gas we're going to need, I feel like CCs 6 and 7 are going to be running more. They're going to come online sooner. We've got these CTs. I feel like the only way to get gas here is to expand Transco. And do the same thing. Talk to Dominion, talk to Transco, see if people want to chip in. When we say do a study, that's kind of what we're thinking about, right? We need more gas to run these CCs. They're coming online sooner. So let's think about that. So help me with that point.
Thank you for the question, Mr. Freeman. And I agree with you. We need more gas. I think we're aligned there. I'd say a couple points. First, while Transco does deliver the vast majority of natural gas to North Carolina, and they are a great operator, highly reliable, great partnership with I believe the commission and the LDCs and Duke. We've all identified that we have a high reliance on Transco. And, you heard Mr. Holman say eggs in a basket, right? That's not saying we couldn't do another Transco expansion, but I would not limit it just to that. MVP Southgate is bringing diversity. ELNG would bring diversity. We're focused here in this hearing on the NTAP through CC's 5. What happens after that, we'll have to see what Mr. Snyder has to say. But right now, that's what we're laser focused on. And I guess the second point to your analogy about PSNC, and I will say that was one of my proudest moments in this role, was being able to figure out that with PSNC and that collaborative effort to create so much customer value. That was great work by all parties. That's not the case for Transco. If you look for Transco's system from the Gulf Coast in particular, it's anywhere between 4, usually 3 and 5, mostly 4 pipelines adjacent to one another. You're not building one pipeline from, a point in Mississippi to a point in North Carolina. It's done in segments. So whether it's Duke or someone else, it's 1 CC, 2 CCs, 3 CCs, they're going to build the facilities to that volume. So I understand what you're saying, Mr. Freeman, about economies of scale. For a brownfield expansion, specifically to Transco Gulf Coast, that same synergistic savings that we experience with PSNC is just not the same case.
One moment. Thank you so much. I don't have any more questions.
Redirect from Duke.
Just briefly, to Mr. Freeman's point about maybe in this moment procuring FT, incremental FT with others maybe involved in our position on ELNG. How would ELNG, as part of a diverse portfolio, not only serve CCs 4 and 5, but also be a tool or a resource for our future portfolio to serve CCs 6, 7 as we go into the future and as potentially load growth increases?
NCSEA asked me many questions about the enhanced services. the enhanced services are not just limited to CC 4 and 5. It's going to help the entire fleet, the state of North Carolina. So if there were CCs 6 or whatever other gas generation could come in the future, that ELNG facility could create value for those as well. So it's not limited to just the value of CCs 4 and 5.
So sitting here today with respect to the NTAP and the resources that we're talking about in this CPIRP, you've stated, and we found through our fuel security evaluation, that ELNG is the least cost option, correct?
Yes, it is least cost with upside to customer value with its enhanced services.
And it also will, well, let me ask it this way. Building ELNG now at this point in our portfolio does not mean we will not seek opportunity to obtain incremental FT in the future, does it?
You are correct. If a CC6 was deemed necessary, that doesn't mean we're going to look to ELNG as that solution. And I would say, Commission, in my rebuttal testimony, we talk about the other entities in North Carolina, PSNC, Piedmont, even City of Monroe and in the City of Greenville, they have LNG. Our consumption as an electric utility is greater than all of them combined, and we have no storage. This is a diversity play. This is helping us optimize our portfolio and create security. And we need more gas storage. And arguably, I would say we need it even more than the LDCs, given the intermittency, non-dispatchable resources that are coming into our portfolio mix.
And finally, with respect to the testimony that we heard and some of the questions that you were given today, the concept of this ELNG as a part of the portfolio, there's been questions about the ability of ELNG to supplant FT in the current portfolio of FT to support the ELNG to actually serve CCs 4 and 5. Can you talk a little bit about your confidence in the capacity market right now and its ability to serve and to work alongside ELNG to serve not only CCs 4 and 5, but be part of the system going forward?
Yes. So through CCs 3, and this is well documented in testimony, with the new firm transportation we have obtained, contracted, it quadruples our firm transportation. We're playing catch up here. But again, the good news is we have a substantial amount of firm transportation rights on interstate system that is coming online. That is not going to be used 100% of the time by those combined cycles. That's one of the great things of how our portfolio is built from a fuel perspective. We can optimize amongst other combined cycles, simple cycles, dual fuel coal. So when you look at that 1.7 billion cubic feet a day of firm transportation, some of that can go to CCs 4 and 5. And when we talk about the Zone 5 market, I had an Exhibit 1 when we talked about the length of Zone 4 to Zone 5 capacity. And I know Witness Fitzhenry put in a graphic of 85 to 95% optimized. That's I can go into that if necessary, but that's not the case. That's not where we are today. Commission, it's hot outside today. I just looked, it's public information. Zone 4 to 5, so gas from the Gulf Coast, that capacity, it's only being utilized 28% today. Only 28%. So there's more than adequate non-peak day gas to help fuel our fleet. And I think that is the beauty of ELNG. It helps lower customer costs and optimize the system we're in.
I have no further questions.
All right, thank you. So I've got a commission question that is not confidential. Mr. Mitchell, what is your response to NCSEA witness Lynn's recommendation that the commission should limit ELNG storage facility to act as a pilot or demonstration project and deny Duke's request to deem ELNG as as reasonable for planning purposes.
Yes, Commissioner, I would say the first item there is he's saying a pilot. So he mischaracterizes what we're actually proposing or modeling to build because there's no new technology here. What we're looking to do is existing technology that has been done component by component at similar scale throughout the country. So there is no technology to quote unquote pilot. And then secondly, on the scale, I believe his testimony talked about doing it in stages or upsizing the tank. That's simply not how a tank works. Once it's built, you can't just raise the top of it. So we feel very confident in the underlying equipment that is utilized in this assumption. And we have to maintain reliability. And the scale that we deemed and we submitted to this commission in PSDR 1615, that shows that the scale that we're proposing maintains reliability. A pilot facility would not.
Okay, thank you. At this point, we need to go into highly confidential attorney's eyes only session. Commissioner Tucker.
Gentlemen, thank you for being here this morning, even with the interruptions. Mr. Mitchell, what other ways can there be LNG storage in North Carolina other than the proposal of the E-LNG?
So we have existing LNG at various facilities through this state. And what we're proposing from if you look at the core components of gas conditioning, liquefaction, vapor, storage tank and vaporization, it's essentially the same thing. The one in my testimony, I believe it's on page 9, and we can walk through those if you'd like. There's 4 different things that we say are a little different for enhanced, and it's no different than what a pipeline does when they provide enhanced services. It's just essentially sizing the facility to be able to provide flexibility.
Okay.
So yes, we could pursue just a regular LNG facility without that flexibility, but I guess 2 things, it really wouldn't be that much different. It'd be the same facility. We would just lose that customer value of the enhanced services.
So you couldn't build a tank farm, LNG tank farm, and then have LNG tanked in from the Gulf Coast? You'd still be able to buy gas in the summer, as you talk about, for customer savings when it was low, this, that, and the other, rather than going to the expense that was divulged in the confidential session.
So your
Yeah.
question is moving it by vessel or train or
Right.
truck. We have looked at those, and even if you were to move it, hypothetically, you
Yes.
would still need tankage in North Carolina to hold it for time of use. So just given the scale of the facility that we're evaluating, it didn't really, the math didn't work. We looked at it at a very, very high level, but we believe firmly that optimizing the gaseous flows into North Carolina into liquid is the most efficient way for LNG to get to North Carolina.
Okay, I thought that may be your answer as far as, I listened to your passion about the fact that you have no storage. Duke, as big as it is, as much natural gas as it uses, it has no storage. My next question, and this will probably be my last, why can't we enlarge the oil backup at CC 4 and 5? And should we have a need to use them a prolonged period of time, that we could not get the relief like we did on the 12th of this month to relax air quality standards so that we could run them for those intermittent times when we're going to be using the ELNG?
Yeah, I would say a few things, and I think that's something public staff recommended we look at, and we've looked at that some. Generally speaking, on-site diesel fuel is size 2 to 6 days of a burn. This would need to be several times that. So when you think about the considerations of that, diesel fuel is not very economic. It sometimes can be economic, but it most of the time is not economic versus gaseous or even LNG. So you have the economic considerations. 2, you have the air considerations. Obviously, you have air restrictions at certain localities on amount of diesel you can burn, and diesel is more carbon emitting than natural gas. And then lastly, one thing that we haven't talked about in this proceeding, but is in, I believe, Appendix I, is replenishment. So, for that level of diesel fuel, the sheer logistics of replenishing the tanks would be challenging. And we already have a fair amount of diesel on the system. So we feel very good about what we have. We just think there's limitations of growing that exposure to those replenishment logistics.
Did you run the numbers on expanding the oil capacity at CC 4 and 5?
I can't speak for IRP, but to that level, I don't believe they did.
Okay. Let me think. There was one other question. Let me look here. For my own edification, had we had the ELNG facility in 2022 when Winter Storm Elliott happened, would we have had 500,000 people in a blackout like happened? Or we would have had enough line pack and enough gas to be able to overcome that situation with ELNG?
I can't talk too much to the details of Winter Storm Elliott, but what I can talk to is the gas supply during Winter Storm Elliott. And specific to Winter Storm Elliott, we only had 14 megawatts lost due to gas supply during the peak. So in that instant, I don't think ELNG would have changed. It potentially could have helped the 14 megawatts, but I don't think that 14 megawatts would have changed that situation much.
So Elliott would have happened to LNG or not?
Again, I'm probably not the right witness to testify to that, but I think
Okay.
what we're trying to look is forward looking when we have we see the storms on the horizon, and this could prevent, if gas supply ever was the cause for any reliability challenges, this could help mitigate it.
Well, I'm sorry, I was thinking LNG would be enough storage capacity. That would be the utopia of natural gas dependability, and we wouldn't have to be concerned about it.
It is a very good asset for the system. However, luckily for our state, Transco's been a good operator, and gas supply hasn't been the primary culprit of that situation or others.
Okay, very well. Thank you, sir. Thank you, Chair.
Okay. Questions on commissioner questions? Mr. Somlovsky?
Yes, Chair Brawley. Thank you, Justin Somolowski on behalf of the North Carolina Sustainable Energy Association. I just have a few questions. First, Chair Brawley started off his questions asking if you were could respond to NCSEA Witnessland's recommendation for a pilot demonstration project. Do you recall?
I do.
And your response was that there's no new technology to be studied, correct?
That is correct.
Are pilots not also used for other reasons beyond studying new technologies?
I'm not an experienced pilot operator, so I
Okay.
can't really respond to that.
So just to polish this point a little bit, on page 11 of your rebuttal testimony, you identified 170 LNG facilities operating in the United States, correct?
According to the FERC, there are more than 170.
But in your testimony, you identified 170.
That is more than 170, yes.
Okay. And then on page 14 of your rebuttal testimony, starting at line 2, while there is currently no operating LNG facility that precisely matches the enhanced operational plan for the company's ELNG facility, the essential components are the same as used in LNG facilities in operation throughout the United States.
That is correct. That's what I said.
So your testimony is still that you are operating these known technologies in a new, different manner than has been already implemented.
Well, I'd say a couple things, Commission. First, this is a modeling assumption. We're not coming with a exact facility here. So I think the scrutinization of that, what that operational plan ultimately is more appropriate for a CPCN. But for what we have here, yes, my testimony says that LNG, we are not aware of any of those 170 facilities that has the enhanced operational plan that we're proposing. However, I think what kind of gets misplaced is we modeled an intrastate LNG system. So that means it is on generically the intrastate network. So that means there is pipeline between that LNG system and the power plant. That happens all over the place. So there's LNG facilities in North Carolina right now. We don't subscribe to those facilities. We're not invested in those facilities or operate those facilities. Does that mean that those natural gas molecules don't come to our power plants? No. Natural gas is a commingled commodity. So I think trying to show that, what we're trying to do is that far from what's done today is a little misplaced.
Okay, but still, even regarding the other LNG facilities within the state that you don't operate, none of those operate in the enhanced functionality.
Not necessarily. I can't speak on behalf of the LDC operators, but let's just use vaporization as an assumption. Our base assumption is that we are going to have vaporization and ready standby. We incur the cost and modeling of that 365 days a year, 24/7. That is what is assumed. We are as punitive as possible on the enhanced features. Are we actually going to do that? Could it be optimized? I don't know. This is just a generic modeling assumption. But LDC operators today, they may do the same practice, but just during extreme winter events when they're ready. They don't model that for 365 days. They may just do it because it's normal operating procedures for a couple of days in the winter. So again, the technology that we assumed and would plan to implement is no different on the vaporization than what LDC providers in North Carolina already do today.
So, but would you agree that part of Mr. Wynn's recommendation for a pilot or demonstration project was to gain operational experience and figure that out for Duke independently?
Well, again, I think it's a little premature because we modeled it LNG service. Experience for who? What if we have a third-party operator that already has experience? It's a little premature and jumping to conclusions on what ultimately may be proposed to this commission.
Potentially, but once we get through a CPIRP, the next step usually is a CPCN, correct?
A CPCN for a generator would be the right place to consider operational and site-specific characteristics of an ELNG facility.
And part of Mr. Lynn's recommendation was to make sure that it is a minimum viable solution being studied and analyzed so that we're not oversizing and overbuilding for these capabilities.
So I would say that was the whole point of our modeling commission, was to validate the fuel security that this ELNG facility provides. So that's exactly what we did in this proceeding, is say, hey, the ELNG fuel security, this is least cost reliable for the customer. The enhanced portion, yes, we have the cost accounted for. It's just too difficult to see what kind of upside customer value will be produced, but there will be something.
I understand, but wouldn't it be nice to understand the benefits to make sure that you can deliver on the promises to the commission of these enhanced capabilities?
Well, again, if we knew how solar was going to perform at an hourly level in the late 2030s, we may be able to quantify it better, but it would cause massive speculation and changing of modeling assumptions to attempt to do so.
Okay, now I'm going to take one more stab at this. Does the company have experience to manage and operate on an hourly liquefaction management schedule and LNG facility?
The company, being Duke Energy Carolinas and Duke Energy Progress, does not operate any LNG today. However, there are other providers in the state that do, and what we modeled was a intrastate service from one of those providers who has experience operating.
Okay. And to fold in one of Commissioner Tucker's questions, he referenced the USLD also co-located on site at certain facilities, correct?
Yes, sir.
Wouldn't it be beneficial to have a minimum viable solution to inform right-sizing storage backup at future CCs?
The PSDR 1650 attempted to do that. That's what that was done, is to say what is the right amount of fuel required to maintain reliability.
Okay. Thank you, Chair Brawley.
Okay, Duke, redirect.
Just briefly on Mr. Simulowski's questions, I just want to, for clarity, I think it might have got a little conflated. You spoke about the additional benefits of the CLNG service, but that was beyond just it serving as a fuel security option for CCs 4 and 5, correct?
That is correct. The modeling and what we proposed in this plan already demonstrate that it is least cost fuel security solution. What we have stated in testimony is we have accounted for the cost of ELNG from an enhanced perspective. However, that unknown future value will be upside for customers.
Another way to say it is ELNG as a fuel security option is not an unknown at all. You're talking about these other options, other benefits.
That is correct. We have a known value for the fuel security portion. The unknown value is the state of Transco renewable operations in the late 2030s. And we've heard the word hedge a lot in this proceeding. And this is generally a hedge to whatever the operating conditions are in the 2030s that we don't know about today.
That's all I have, Chair Brawley.
Okay. Gentlemen, you are excused. We're going to take a 10-minute recess and then we will start with coal generation and supply.
Thank you. Thank you.
Okay, let's come back order and go back on the record. Good afternoon, gentlemen. You're already sworn, so who's handling? Mr. Summers?
Yes, sir.
Your witnesses, sir.
Thank you, Mr. Chairman. First, Mr. Verderame, would you please state your name for the record?
John Verderame.
And Mr. Flanagan?
Jeffrey Flanagan.
And are y'all the same panel that testified on direct about 2 weeks ago?
Yes. Yes.
On behalf of the panel, Mr. Verderame, did the panel cause to be pre-filed rebuttal testimony of some 14 pages on or about May 14, 2026?
We did.
And do you have any changes or corrections to the pre-filed rebuttal?
We don't.
I asked you the same questions today. Would the panel's answers be the same?
We would.
Did you also cause to be pre-filed a summary of your rebuttal testimony on or about June 5th, 2026?
Yes.
Do you have any changes to your summary?
No, sir.
And there's no confidential information in your rebuttal testimony. Is that correct?
That's correct.
Mr. Chairman, this time I would move to admit the rebuttal testimony of the coal generation and supply panel as if given orally from the stand, along with their summary as well.
Okay. The coal generation and supply panel rebuttal testimony of Jeff Flanagan and John Verderame consisting of 14 pages as filed on May 14th, 2026, and rebuttal witness summary as filed June 15th, 2026 is identified and without objection admitted as if delivered orally from the stand.
Thank you, Mr. Chairman. The panel is available for questions.
Sigfer,
No questions. Thank you, Chair Brawley.
EDF,
Good afternoon. Just one topic I want to cover. Ben Smith from Environmental Defense Fund. Turning to page 9 of your rebuttal testimony. Okay, beginning at line 10, it reads, although it is true the companies have proposed increases in coal unit O&M spend, the O&M plans are limited and designed to prudently maintain reliability in the face of growing customer demand and increasing wear and tear on aging baseload design units that now operate as cycling units. Did I read that right?
That's correct.
I want to focus just on that last piece of it and just make sure I understand what you're saying here. Increasing wear and tear on aging baseload design units that now operate as cycling units. Can you talk me through how they've operationally changed and what it means to be a cycling unit versus a baseload unit?
Yeah, so the coal units as designed and operated for the first 30, 40 years of their life cycle were really baseload units. They would go through an outage, start back up, and then run mostly full load through the period until the next outage. Over time, through economic dispatch, with the combined cycles that we have that are more efficient, those coal units have become really load followers. So it's a different run profile than what you've seen in the past. And the O&M that's associated with the increased cycling, and I'll define cycling a little bit. Most of the service is on starts and things like that. So as you start a motor, as you start a pump, it increases the service life on them. So it needs more O&M to rebuild those components. So with the coal units following the load like they do now due to economic dispatch, you just see more service hours and need for increased O&M spend cost on those. So, as a definition of a cycling unit, they all run a little bit differently. So Marshall, which is my primary station, units 1 and 2, may be offline in reserve for a week or two at a time. And then they'll start up and run through a peak period. They're typically, because of their cost, they turn down first. So as you start, after the peak of the day, they'll start loading them down first. And then, you get to a weekend, you may take the units out of service. Units 3 and 4 mostly stay online. They do follow through the load cycle most days. Minimum load in the evening, they'll ramp back up to full load. So it's not like a simple cycle CT that you would see cycling on, for 2 or 3 hours, because they don't have the flexibility to be able to do that. But they do cycle through the load range and then periodically off and on into reserve periods as the system needs, just plainly due to where they are in economic dispatch.
No further questions.
Thank you, Mr. Smith. Public staff?
Thank you, Chairman. Will Freeman for the public staff. My memory is that Commissioner Tucker asked you if these were paid for, and I got a lot of emails. I didn't know if you were going to file an exhibit, or can you tell me about the unamortized balance? How much is owed on these still?
Yeah, and so my understanding, this was in the public staff thermal resource panel testimonies, page 17, lines 3 through 8. It's estimated about 6 billion between all the sites, the coal sites. I can break that down if you need me to by site.
6 billion is good. I have no more questions. Thank you, Chairman.
Redirect?
No, sir. Thank you.
Okay, Commissioner questions. On the last page of your rebuttal testimony, you make the following statement. The proposed strategic extensions in operations at certain coal units introduce more risk to the reliable operation of the system, which the companies have determined can be managed at this time. Is Duke's proposal to strategically extend certain coal units unusual, or is it consistent with a broader national trend where utilities are reassessing coal retirement timing?
That probably starts with me. I think it follows a broader trend, but I do think it's consistent with, if you look, especially this far out, if you're looking at, the 8 to 10 year time frame, we've got an opportunity to invest to ensure that we're improving reliability of these units, over the next 8 to 10 years. So a 1 or 2 year extension is consistent with what I've seen other utilities do as well.
Okay, thank you. In the last CPIRP, we had some interveners who recommended an extension of coal retirement dates beyond what Duke was proposing. In this proceeding, while some parties have advocated for earlier retirements, am I correct that no party has recommended extending the retirement dates beyond those currently proposed by the company?
I'm not aware of.
So.
Okay. Mr. Verderame, as someone who has spent decades evaluating the costs, risks, and operational performance of generation assets, how would you answer this question that members of the public with no experience in energy in the energy industry might ask? Why can't the companies simply invest additional operations and maintenance dollars into these coal units, extend their lives further beyond these strategic extensions, and continue obtaining capacity from assets that are already built?
I think it's a fair question, Chair Brawley, and I think there are two components to it. We've spoken to it both at length. I'll speak, strictly to the fuel risk components. And I've spoken about this at length as well. The company accepts that these strategic.
Sir, would you pull your microphone closer?
Company accepts that these strategic extensions make sense as a pathway for us to transition to other generation. But extending them forever is not really feasible, right? I think with every extension, we introduce customers to both cost risks and reliability risks. These assets have been great assets for 50 years. But I've spoken at length around the evolving coal supply industry, the risks around that, the increasing costs, even the aspect of how these units operate in dispatch space. And we've got mitigants to some of those, right? But we cannot expect these units to run to failure, to use a technical term. I think that exposes customers to risk beyond transitioning in that
strategic way we've drawn out. But Ms. Flanagan, you can talk more about the, the assets themselves.
Yeah, I think the supply chain concerns, just as other utilities have retired coal units, the ability and support structure from original manufacturers to support the coal units has kind of gone away. So some of those problems that we've seen with increased difficulty in getting parts and replacing parts, technical experience to be able to work on those systems has given us a lot of cause for concern for extending too much beyond where they currently are. It's obviously a risk that we're working through with increase in stocking items and looking at potential degraders that we've got for how we can make repairs. But there is an increasing risk as time goes on.
Okay, thank you, sir. Questions from commissioners? Commissioner Gaida?
Yes, gentlemen, last time I asked you a question about rail issues, and you mentioned that to kind of deal with transportation security, the company was acquiring coal hoppers, if I recall that correctly.
Yes, sir.
Yep. Are the so I'm not questioning that strategy or don't have any questions about the strategy, but the cost, are the at end of life, are the coal hoppers, well, a day will come you won't need them anymore. Is that are those factored into any decommissioning costs that have been put into models or put into the cost of stopping operation at the coal facilities? As far as liquidating or getting rid of those assets?
Yeah, no, that's a great question. I think as part of the broader scheme of including them into costs, I would say no, but I think that strategy is built around extending if we're going to extend the life of the units, we want to make sure we have the infrastructure behind it. And quite honestly, the way we've structured these purchases, they're not very much more than the scrap value of the cars. So we did an analysis around continuing to lease them or to own them, and owning them with the ability to scrap them at the end of their life far exceeds kind of that expense of continuing to lease them, but also provides security that we now have control as this, I guess, broader supply chain devolves and no new cars get built. We now have control over those assets. We don't have to worry about them becoming more valuable in time because they're a diminishing commodity in themselves.
Questions on commissioner questions? None.
None, thank you.
Anything from Duke?
No, sir, thank you.
Okay. Well, on the exhibits, there were 4 exhibits I identified and did not admit. I believe we've admitted all other exhibits that were offered. However, without objection, any pre-file testimony or any pre-file cross or redirect exhibits which were marked for identification and for which I have not yet made a ruling on admission are admitted. Post-hearing briefs and proposed orders are due no later than 30 days from today. And that will.
Chair Brawley?
Yes, sir.
I apologize. One exceedingly minor item here. We did make a late filed exhibit at the commission's request. It's Duke Energy Transmission Interconnection Rebuttal Late Filed Exhibit 1. If the commission desires, we would
I was actually going to ask you. I understand that was filed. Okay, we'll go ahead.
So assuming the commission would like to do so, we would move that into the record as well at the appropriate time.
How about right now?
Perfect. And other than that, we have no other procedural items to bring to your attention.
Okay. All right. So I'll finish the other. If there's anything for which I've not yet made a ruling on admission, they are admitted. Proposed hearing briefs and proposed orders are due no later than 30 days from today. That will be Friday, July 29th. All right, is there any additional business to come before the commission? Gentlemen, you are excused. The hearing is concluded and we are adjourned.
Well done.